Hey everyone, and welcome to Jail is the Rule, our discussion on bail jurisprudence under the UAPA. I'm Dhaval, and today's session is being conducted by the Law and Society Committee. And uh, the last week's events, particularly Father Stan Swamy's unfortunate demise on July 5th, has brought this issue under great relevance and brought forth the draconian and terribly brutal measures under the UAPA undeniably and unignorably before the nation. So during the course of the next hour and 1.5 hours, we'll have our esteemed guests and speakers uncover this issue for you. We also have Ms. Megha Mehta today, who graduated from National Law School in 2019. She's also done her clerkship under the late Justice M. Justice M. Charagadar. And while her mainstay is criminal law and sexual offenses, she has amassed great experience under bail under special laws during her clerkship. I'd also like to thank all our attendees for sparing their Saturday evening and all our guests for taking out time from their busy schedules to come and engage with us. If the speakers are ready and if Ms. Megha is ready, we could start with the session and I'd hand over the proceedings to her.
Yeah. Hi, thank you, Dhaval. So I'll just start by contextualizing the issue first for everybody who's joined in, and then I'll hand it over to the speakers. So I'm pretty sure, I mean, everybody has background information as well, but just in case for those who've not read up too much on this issue. Father Stan Swamy was a Jesuit priest and a tribal rights activist based in Jharkhand, and he was also one of the accused in the Bhima Koregaon Elga Parishad case. It's worth noting that he was not one of the original accused in the FIR which had been filed in 2018. So, what exactly had happened was that in January 2018, there was a gathering of Dalits near Pune to commemorate the 200th anniversary of the Battle of Bhima Koregaon, which was fought by the British Army against the Peshwas. And the British Army comprised a large number of soldiers from the Dalit community. So, that event is also seen as a kind of commemoration um, of victory over caste oppression. And certain violence took place at that time, which the Pune police claimed was linked to another event called the Elgar Parishad, which was held at Shaniwar Wada. And they arrested certain activists claiming that the event was organized as part of alleged Maoist activity. In 2020, after a new government came into power in Maharashtra, the investigation was taken over by the NIA, which is a central agency which comes under the Union Ministry of Home Affairs. And as we all know, there's a different government in power over there. And in October 2020, the NIA released a 10,000 page charge sheet with fresh names, with allegations against fresh names, including that of Father Swamy. And the specific allegation that the NIA made against Father Swamy was that he was conspiring to bring together Dalit and Muslim forces to take on the fascist government at the center. And moreover, the NIA accused him. So, Father Swamy was the convener of the Persecuted Prisoner Solidarity Committee, and the NIA claimed that this was a frontal organization for the CPI Maoist, which is a banned organization. And these kind of allegations were made against him, basically claiming that he was linked to Maoist forces and that incriminating literature was allegedly recovered from him. Father Swamy's plea for bail was rejected by the NIA court. He approached the Bombay High Court seeking interim bail, and it was his desire right from the beginning that he should be allowed to go back to his home in Ranchi and be with his friends. He was suffering from Parkinson's disease and various other age related ailments. Unfortunately, his request was not allowed. In May, the High Court did direct the state prison authorities to shift Father Swamy from the Taloja Central Jail, where he was lodged, to the Holy Family Hospital, and he was asked to bear the cost of his own treatment. Later, he tested positive for COVID-19, and unfortunately, he passed away recently. Father Swamy had filed a petition before the High Court as well, challenging the constitutional validity of Section 43D5 of the UAPA, under which he was accused of criminal conspiracy. And he said that the kind of obstacles that the UAPA creates for an accused to be granted bail are violative of the fundamental rights under the Constitution, and that the NIA had virtually made it impossible for him to apply for bail. And therefore, in that light, and also in light of the recent Delhi High Court judgment, which set a really new precedent by saying that, the protesting should not be seen as a terrorist activity under the UAPA. It's really important that we have a discussion on this, and also in light of the history of the UAPA, given the kind of defenses that the people make for it in light of national security and all of that. We feel it's important to have a discussion on this. We will have three speakers leading this discussion today. We have Ms. Rebecca John. She's a senior advocate based in Delhi and one of the leading commentators on criminal justice reform and procedure. And she had also represented Ms. Priya Ramani in the defamation case filed by MJ Akbar recently. We have Mr. Mihir Desai. He's a senior advocate and a human rights lawyer based in Bombay and one of the co-founders of the Human Rights Law Network. And he had also represented Father Swamy before the Bombay High Court before his death. So it would be lovely to hear from him. And finally, we have Mr. Abhinav Sekhri, who also frequently publishes scholarship on criminal justice reform for law students. I would highly recommend checking out Proof of Guilt on Blogspot. And he's also a criminal lawyer based in the Delhi trial courts. So we'll start with Rebecca Mann to share her thoughts on the issue.
Thank you very much, and thank you for this opportunity to speak today. Your topic is jurisprudence, bail jurisprudence under UAPA. So perhaps I should start by talking about jurisprudence for grant of bail under general law, under ordinary law. The object of bail is to secure the appearance of the accused at trial. The approach of the court in examining applications for bail has therefore necessarily to center around the issue of whether continued incarceration of the accused is necessary and imperative towards securing the end of obtaining his presence when required. Curtailment of personal liberty during trial has therefore to be limited to those cases in which it is absolutely essential to do so for the reason that the accused is a flight risk or will otherwise influence the course of the trial. If no such apprehension can legitimately be expressed, there is no reasonable ground to keep the accused in custody. The Supreme Court recognized this principle in Sanjay Chandra versus CBI, 2012, Volume 1, SCC, page 40, when it said, and I quote, "From the earliest times, it was appreciated that detention in custody pending completion of trial could be a cause of great hardship. From time to time, necessity demands that some unconvicted persons should be held in custody pending trial to secure their attendance at the trial. But in such cases, necessity is the operative test. In this country, it would be quite contrary to the concept of personal liberty enshrined in the Constitution that any person should be punished in respect of any matter upon which he has not been convicted, or that in any circumstances he should be deprived of his liberty upon only the belief that he will tamper with witnesses if left at liberty, save in the most extraordinary circumstances." In a case where bail was granted despite the fact that the charge sheet against the accused claimed that the victim had died of multiple gunshot injuries at the hands of the accused, the Supreme Court held in a case titled Prabhakar Tiwari versus State of Uttar Pradesh, 2020, Volume 1, SCC, page 648, that, and I quote, "The offense alleged no doubt is grave and serious, and there are several criminal cases pending against the accused. These factors by themselves cannot be the basis for refusal of the prayer for bail," unquote. Way back in 1978, Justice Krishna Iyer in Babu Singh versus State of Uttar Pradesh said that the considerable public expense in keeping in custody when no danger of disappearance or disturbance can arise is not a negligible consideration. Equally important is the deplorable condition, verging on the inhuman, of our sub-jails, that the unrewarding cruelty and expensive custody of avoidable incarceration makes refusal of bail unreasonable and a policy favoring release justly sensible. Contrast the jurisprudence that I've just referred to with the jurisprudence developed by our courts with respect to grant or refusal of bail under a cocktail of special legislations. Over the years, several special statutes have been enacted for a wide variety of offenses, creating exceptions to general criminal law. For instance, the now repealed Terrorist and Disruptive Activities Prevention Act 1987, the Prevention of Terrorism Act 2002, the Unlawful Activities Prevention Act 1967, the Prevention of Money Laundering Act, the Narcotics, Drug and Psychotropic Substances Act. For the purpose of this discussion, I will compare the bail provisions under 4 statutes, namely NDPS Act, BACOCA, PMLA, and UAPA. Under Section 37 of the Narcotics, Drug and Psychotropic Substances Act, NDPS, the twin conditions to be satisfied before bail is granted is that the court has reasonable grounds for believing that the accused is not guilty of an offense and that he is not likely to commit an offense while on bail. Section 21(4) of MACOCA and Section 45 of the PMLA repeat the same language. However, Section 45(1) of PMLA has a proviso, an additional proviso, which is not found in the other 3 statutes. The proviso reads as under, provided that a person who is under the age of 16 years or is a woman or is sick or infirm or is accused either on his own or along with other co-accused of money laundering, a sum of less than 1 crore rupees may be released on bail if the special court so directs. The proviso which specifically applies to PMLA does not find mention in any of the other special statutes that I've referred to, including UAPA. It is worthwhile to note that the proviso to Section 45 PMLA is somewhat similar to the first and second proviso or to Section 437(1) of the Code of Criminal Procedure relating to bail. Section 43(d)(5) of the UAPA is different in the language it uses while considering the issue of bail. It does not expect the court to be satisfied that there are reasonable grounds for believing that an accused is not guilty of an offense and that he is not likely to commit any offense while on bail. Rather, it states that the court, upon examining the case diaries or the charge sheet, must not grant bail if there are reasonable grounds for believing that the accusation against such person is prima facie true. The provisions governing bail in the Code of Criminal Procedure 1973, namely the ones that you see under sections 437 and 439, begin with the phrase, court may direct that any person accused of an offense and in custody be released on bail. Contrast this with section 43D of the UAPA, which reads, notwithstanding anything contained in the code, no person accused of an offense punishable under chapters 4 and 6 of this act shall, if in custody, be released on bail. General law empowers a court to grant bail. UAPA allows the court to refuse bail. The conditions for grant of bail with respect to NDPS, MACOCA, PMLA acts demand that the court return a finding that the accused is not guilty of the crime and is not likely to commit any offense in the future. And in the UAPA, that the allegations against the accused are not prima facie true. This, I submit, is designed to keep an accused in custody in perpetuity. This, I also submit, goes counter to the jurisprudence of bail, which India has otherwise always followed. Recognizing the near impossibility of certifying at the stage of bail that an accused is not guilty or that is unlikely to commit an offense in the future, some of these provisions with respect to some of these statutes have been diluted by the Supreme Court. While considering bail provisions under MACOCA, The Supreme Court in Brahmjit Singh versus State of Maharashtra, 2005, Volume 5, SCC 294, held that the wording of 21(4) of Makoka does not mean that the court must arrive at a positive finding that the applicant is not guilty of an offense under the Act. The Supreme Court recognized the absurdity of the twin conditions also for the reason that having granted bail to an accused person on the ground that he is not guilty of an offense, it would be impossible for the prosecution to obtain a judgment of conviction. Section 21(4) of Makoka, the Supreme Court held, must be construed reasonably so that the court is able to maintain a balance between the final judgment and an order granting bail pending trial. More recently, in Nikesh Tarachand Shah, 2018, Volume 11, SCC 1, while dealing with Section 45 of PMLA, the Supreme Court read down the twin conditions to be satisfied under 45(1) of PMLA and held, and I quote, "We must not forget that Section 45 is a drastic provision which turns on its head the presumption of innocence, which is fundamental to a person accused of an offense." The threshold for grant of bail under UAPA is in fact lower than the other special statutes mentioned in the earlier part of my address. During parliamentary debates while introducing the UAPA Amendment Bill 2008, and while talking about bail provisions, the then Home Minister, Mr. P. Chidambaram, stated, and I quote, "Please remember that in POTA and other acts, it was the other way around. The court must come to the conclusion that the accused person is not guilty of the offense and that he's not likely to commit any other offense while on bail, which really means prejudging the case. So what we have is, you can say, refuse bail only under one circumstance, namely, if on a perusal of the case diary or the report under Section 173, you come to the conclusion that there are reasonable grounds to believe that the accusations against the accused are prima facie true. Only then the court can decline bail. Again, the High Courts and the Supreme Court have ample powers, and this does not in any way bind the High Courts and the Supreme Courts. This will apply mainly to the trial court. Perverse as these provisions are, I make the point that even Parliament did not envisage a situation where there would be arbitrary and blanket denial of bail. But what made it worse was the judicial interpretation given to 43(d)(5) of the UAPA by the Supreme Court. In the judgment of National Investigating Agency versus Zaroor Ahmad Shah Watali, 2019-5 SCC, page 1, the Supreme Court held, and I quote, "By its very nature, the expression prima facie true would mean that the materials evidence collated by the investigating agency in reference to the accusation against the accused concerned in the first information report must prevail until contradicted and overcome or disproved by other evidence, and on the face of it shows the complicity of such accused in the commission of the stated offense. It must be good and sufficient on its face to establish a given fact or the chain of facts constituting the stated offense unless rebutted or contradicted." While taking a serious view of the Delhi High Court examining the material against Watali and coming to the conclusion that the material taken together did not make out a prima facie case against him, or that some of the material was inadmissible in evidence, the Supreme Court itself then proceeded to meticulously examine the evidence to come to the conclusion that the prosecution had established its case. The argument of the NIA before the Supreme Court was that the High Court had conducted a mini trial. However, the Supreme Court, in dismissing the High Court's order, also conducted a mini trial. The Supreme Court stated that there was a high burden on the accused in terms of Section 43(d)(5) UAPA to demonstrate that the prosecution had not been able to show that there exists reasonable grounds to determine that the accusation against him is prima facie true. It was never the intention of Parliament to create a completely insurmountable barrier for grant of bail under UAPA. Interestingly, this is also recognized by the judgment in Watali, as it states that the degree of satisfaction is lighter when the court has to opine that the accusation is prima facie true as compared to the opinion of not guilty of such offense. However, Watali still goes on to create a threshold which makes it near impossible for the accused to be released on bail. To reiterate, the Supreme Court held that the materials evidence collated by the investigating agency against the accused must prevail until contradicted and overcome or disproved by other evidence. How is an accused supposed to demonstrate that the case of the prosecution does not cross the prima facie threshold unless, one, there is some examination of material, a practice that the Supreme Court deprecates, and two, how can the material collated by the prosecution be contradicted without evidence being led by the accused? Can this exercise be concluded in a reasonable time frame? If it cannot, is it just, reasonable, or fair to hold an accused in custody for such long periods of time? In the Delhi riots case, on last count, the prosecution is seeking to rely on 740 witnesses in a charge sheet filed with respect to FIR number 50 of 2020 by the Special Cell, in which several members of civil society, students, and activists are charged with offenses under the UAPA. Even a dedicated court that has been assigned for purposes of this case has so far not crossed the stage of Section 207 of the Code, which is supply of copies to the accused persons. Most of the accused were arrested in the case around March, April of 2020. The situation in the Bhima Koregaon matter is much worse. The first arrest in the case by ATS Pune was made in June 2018. To this day, the trial has not commenced. As I see it, it will take decades for both these trials to be concluded, and it remains to be seen whether any of the accused persons will be released on bail. The phrase prima facie, contained in Section 43D5, also poses another problem. As we are aware, charges are framed by a court when there is a prima facie case against the accused. Does this mean that once charges are framed, an accused cannot be released on bail because a court has found prima facie material against the accused? Does it also mean that the only window open for an accused is the period between filing of the charge sheet and the framing of charge? But for this stage, the Supreme Court in Vatali has said that the accusations must be accepted unless they are contradicted or disproved. Even before the 2008 amendments to the UAPA, which brought in Section 43D5 and other similar draconian provisions, courts were reluctant to look at evidence at its face value, evaluate the same, and release persons on bail if they were charged under a statute that dealt with terror-related crimes. In a case called State versus Tariq Ahmad Dar and others relating to the 2005 Delhi serial bomb blasts, I appeared for a student from Kashmir University, Mohammad Rafiq Shah. Rafiq was attributed the role of planting a bomb in a moving bus. Even during his interrogation in custody, Rafiq consistently and repeatedly took the defense that he was not present in Delhi on the day of the blast and was in fact attending his classes in Kashmir University. He pleaded with his interrogators to have the record collected from the university to verify this claim. During the trial, special cell officers conceded that they were aware of his claim, but that they could not verify its truthfulness, although they had written to the registrar of the university in the winter of 2005. They denied receipt of any information from the university in this regard. It was left to Rafiq to produce witnesses in his defense from the university, who brought the original record of that time to show that he was a bona fide student and the attendance registers marked his presence in class on the day of the incident. Professors who took classes for Rafiq on that day also deposed in favor of Rafiq. The court in its final judgment accepted Rafiq's plea of alibi and acquitted him of all charges. That happened 11 years after he was arrested, and during this period, he was denied bail. I may add that the case of the prosecution rested on the evidence of a singular witness who was thoroughly discredited in cross-examination. In the final judgment, the trial court also came to the conclusion that the witness's testimony was fabricated. However, Rafiq could not succeed in any of the bail applications he moved after the testimony of this witness was recorded. And this highlights the mindless weightage given by courts to the label attached to a case. This labeling of cases as serious is argued by the prosecution only while opposing bail. There seems to be no parallel urgency on the part of the prosecution to produce evidence, test its veracity, and conclude trial within a foreseeable time frame. The idea, therefore, is to incarcerate targeted individuals for as long as possible, denying them bail throughout on the ground that there's prima facie material against them, but not producing that material because that would eventually bust their claim. Some of the anxiety arising out of delayed trials is reflected in the judgment in K. Najib versus Union of India, 2021, Volume 3, SCC 713. The Supreme Court held, it is thus clear to us that the presence of statutory restrictions like 43D5 of UAPA per se does not oust the ability of constitutional courts to grant bail on grounds of violation of Part 3 of the Constitution. Indeed, both the restrictions under a statute as well as the powers exercisable under constitutional jurisdiction can be well harmonized. Whereas at commencement of proceedings, courts are expected to appreciate the legislative policy against grant of bail, but the rigors of such provisions will melt down when there is no likelihood of the trial being completed within a reasonable time, and the period of incarceration already undergone has exceeded a substantial part of the prescribed sentence. Such an approach would safeguard against the possibility of provisions like 43D5 of UAPA being used as a sole metric for denial of bail or for the wholesale breach of constitutional right to speedy trial. In the recent judgment of the Delhi High Court, in matters relating to the bail of Asif Iqbal Tanha, Natasha Narwal, and Devangana Kalita, it was held that, and I quote, in our view, on an objective reading of the allegations contained in the subject charge sheet, there is complete lack of any specific, particularized, factual allegations. That is to say, that other than those sought to be spun by mere grandiloquence contained in the subject charge sheet that would make out the ingredients of the offenses under sections 15, 17, or 18 UAPA, foisting extremely grave and serious penal provisions engrafted in sections 15, 17, 18 UAPA frivolously upon people would undermine the intent and purpose of Parliament in enacting a law that is meant to address threats to the very existence of our nation. Wanton use of serious penal provisions would only trivialize them. Whatever other offenses the appellant may or may not have committed, at least on a prima facie view, the state has not been able to persuade us that the accusations against the appellant show commission of offenses under sections 15, 17, and 18 UAPA, unquote. The Delhi High Court further held that since no offense under 15, 17, and 18 was made out on a prima facie appreciation of the charge sheet, the limitations and restrictions for grant of bail under 43D5 of the UAPA would not apply, and the court would fall back on the ordinary considerations for grant of bail listed in the CRPC. 3 days later, a vacation bench of the Supreme Court, in a special leave to appeal petition filed by the state, passed an interim order that the impugned judgment would not be treated as a precedent and may not be relied on by any of the parties to any of the proceedings. We, of course, anxiously await the final outcome of the case. Even during the COVID-19 health pandemic, when the Supreme Court asked various high courts to constitute high-powered committees, or HPCs, to determine the class of prisoners to be released on interim bail as a measure to decongest jails, the high-powered committees released prisoners accused of murder, but created exceptions against release of those accused persons under special legislations, including UAPA. I would have thought that these high-powered committees would have considered the age and health vulnerabilities to be the basis for such release. The classifications done on the basis of particular statutes and particular investigating agencies were wholly contrary to Article 21 protections. And as we saw in the case of Stan Swamy, exposed old and vulnerable persons to the virus. Stan's age, his Parkinson's ravaged body, the COVID he contracted in jail, ought to have made him the prime candidate for release under HPC guidelines. But the deployment of UAPA against Stan made sure that he that that did not happen. The law was used and converted into a tool of oppression. I did not know Stan Swamy, but I mourn the injustice of his death. Thanks.
Thank you so much, ma'am. So that's a very interesting point you made. If I understood correctly, what you meant is that even the law as it was originally designed was only meant to kind of give a discretionary power to courts to deny bail where there is a prima facie case. But the Supreme Court has ended up interpreting it as a kind of mandatory requirement that wherever there is a prima facie case, bail cannot be granted in any circumstance, if I understood it correctly.
Yes, what I meant was I don't for a minute wish to state that the provision is a provision that is that we would like to celebrate. Not at all. When you look at general law and you look at this provision, it is a perverse provision. However, I think in the judicial interpretation of the provision, what was earlier expected by Parliament, the judiciary has gone far beyond that and has made it almost impossible for accused persons to be released on bail. Because in Batali's judgment, the Supreme Court said that unless the material placed on record is contradicted or otherwise disproved, bail cannot be granted.
Thank you so much. That's a very interesting point you highlighted. Mr. Desai, would you like to speak now? You had commented, I read a news article where you commented that the NIA regularly opposes bail in matters under the UAPA, including Father Swamy's matter. And this is even though they never sought for any custodial interrogation of him in the first place. So if you could share your thoughts on that.
I don't mind sharing my thoughts, but I think Abhinav was not feeling too well and he wanted to go.
Okay,
If
sure.
let him.
Yeah, definitely. Yeah. Hi. Uh,
Hi.
Sekhri, I think you represented Mr. Tanha before the Delhi High Court in the Delhi riots case, and I'm sure you have a lot of takeaways from that relating to how bail jurisprudence works under the UAPA. So we would love to hear that from you.
Hi, thanks, Mika. So I was part of the broad legal team that was there for Asif, but Rebecca ma'am has already covered, frankly, what is there to be said about the judgment. Not only what is there to be said about the judgment, but the fate that it met 3 days later in the Supreme Court. So, having said that, what I wish to do was to speak about the issue of UAPA bail jurisprudence by starting and placing it within a larger context, and then sort of look at the UAPA specific issues at the same time, also flagging it, just as Rebecca ma'am also did, just to keep contextualizing it within the larger framework of law as it is. And since ma'am has already covered a fair bit about the general law, special law issues, I wouldn't have to burden the conversation with that anymore. So without further ado, what I really want to, bring forth is an idea about what do we have in bail jurisprudence in terms of a conflict between the executive and the judiciary. Now, where am I going with this? Ordinarily, yes, you have bail as a measure to ensure the appearance of an accused person. But at the same time, there are various other factors that are looked at while deciding the issue of bail. One of these is obviously the gravity of the crime. But in all of these factors, ultimately what is happening is that you have a situation where the executive machinery in the form of the police, the NIA, or any other agency which you may please, comes with a set of allegations to court. It comes with its narrative, and it asks, when the accused is there asking for bail, it is this narrative that the accused is trying to contend with. And the task before the court is to figure out whether or not bail ought to be granted. And in this regard, the role of the court is to test that narrative. Because if the court is unable to test that narrative, frankly, the role of the court is then nothing more than to just rubber stamp the decision by the executive. Because where the executive then says, the police says that, look, I don't oppose bail. Is it that only in those cases courts are being allowed to grant bail? Surely not. Which is where we come to the idea of courts having discretion to decide, no matter what the allegations might be, that look, in certain cases, we agree that bail ought to be granted. This tussle between, and surely in other systems, it would be different where you might have fairer investigative agencies which don't oppose bail at every turn. But from practice, I think it's fair to say that hardly in any case do you find that the police don't oppose bail. It is the rarest of the rare case where you find that the police actually agrees, okay, there is no need for an opposition. So you have this as the standard model where accused person applies for bail, police opposes, and the strength of the narrative is what you are fighting against. This really is the heart of bail jurisprudence, right? My broad argument in the next 15 or so minutes is to suggest that offenses such as the UAPA, statutes such as the UAPA rather, have so fundamentally altered the role of the court in this issue of bail jurisprudence by really denuding the power of the court to be able to test that narrative, right? And so what happens in these situations is that the cards are so heavily stacked against accused persons that surely this is not a regime that can be classed as just, fair, or reasonable, and is not a regime that should withstand constitutional scrutiny should the day come. So that's the broad sort of argument that I want to develop. And now let's look at the UAPA as the test example of this. Within the criminal justice system, at least now at the stage of bail, because that's what we are focused on, what you have is the executive's ability to level allegations against you. And these are not allegations such as, oh, a person committed a theft. The allegations of that nature are going to be in the form of a complaint that comes to the police, right? So looking at the example of the Bhima Koregaon cases that are ongoing, there were certain allegations that came to the police in the form of a written complaint. It is the role of the police to translate that written complaint into accusations that fit specific headers under law. And this transformation is really critical because what you have is unbounded discretion with the police to fit in a crime within various statutory contexts. So looking at this example itself, the allegation would be that there is an uprising that is being attempted. I am paraphrasing to a certain extent. You can take the Bhima Koregaon cases, or you can even take the CAA protest cases. The allegations are that there are persons conspiring to, let's say, foment an uprising against the government. Even this could be under sedition, right? It could also be under the UAPA. And that choice is something ultimately that is with the police. It is not with the courts. That choice rests with the police. And the strength of that choice is something that we really need to look hard at. Because what that does is that the moment that choice is made, the rest of the process, the path that your case will follow, gets defined. To give you an example, suppose a case is filed under sedition as opposed to the UAPA. As Rebecca ma'am explained, where you would go under is the general law on bail. You would go under 437 or 439 of the CRPC. 43D would not be attracted in those cases. And so in that moment, the moment the police decides to invoke a certain offense, that has a somewhat irreversible impact on the process that the case is going to follow. Now, where offenses and statutes such as the UAPA make things even worse is the manner in which the crime itself is defined. And this is something that the judgment passed by the Delhi High Court in the petition of Asif Iqbal Tanha. It looks at this squarely because it looks at the offense under section 15 of the UAPA. And the court says that taken at its face value, the offense can become unconstitutionally vague. which is why you need to read it in a manner so as to not render it unconstitutional. As we know that the judgment has been stayed, but keeping that aside, the point nevertheless stands that offenses that are defined in as broad terms as possible allow the police to fit in various kinds of conduct within what might not otherwise be, let's say, core anti-terror activity or core unlawful activity. And all of that just expands what is already boundless discretion even further. And taking that step back, where you find yourselves is that the police have even more powers to define the life of a case than what you would otherwise be ready and willing to give them. This is the kind of power that the system is vesting in the executive. And it's something that really deserves careful attention. Because when we define a crime broadly, it is not that the consequences, it's convenient to say that, sure, you will be able to prove your case at trial. But as was already indicated, that stage of trial is something that rarely, if ever, comes. Just to look at the data that has been presented by the NCRB in respect of pending investigations, it's not surprising to find that the UAPA pendency rates at the level of investigations are one of the highest as far as offenses under special local laws are concerned. Pending investigations under the UAPA are at a state of 77%, as opposed to other crimes where the pendency rates are at around 40–45%. And so when you look at this together with the pendency rates at the trial stage, the UAPA has a 95% case pendency rate, which then brings you back at the idea of empowering the executive in this manner and the kind of consequences that it has on the process. Now, a rational person is going to argue that, look, this is a serious situation and we need to have safeguards. What are the safeguards that the UAPA has? Frankly, the only safeguard within the process itself is classified under section 45 subclause 2, where the UAPA requires that sanction for prosecution must be given only after an independent review of the evidence gathered in the course of the investigation is made. By whom, however? By the executive itself. So what you have is, therefore, within the UAPA context, an executive that is overpowered. Where you then find yourself is a need for there to be some pushback against this. And that is something that is totally absent in the context of bail, which is the most important context given the overarching situation of pendency, of cases not being proved at trial. And what do you have there is section 43D5, which provides for what is a prima facie test. Now, just to go back to the legislative debates, and as was already discussed, the introducer of the bill, Mr. P. Chidambaram, mentioned that 43D5 did not have the idea that bail would be forever closed to the accused. But at the same time, it's interesting to look at the comments made by another member of parliament that day, Mr. Asaduddin Owaisi, where he, and I'm just reading from the debates here, where he talks about the bail clauses. And he says, and I quote, "Another issue is about bail. This is a limit on judicial discretion. Any public prosecutor will stand up and oppose bail. What will the case diary say? Will the case diary write flowers about the accused? The case diary will, of course, follow what is there in the charge sheet and what is there in the FIR. You are using words to cover up all these things." And that really is the long and short of it. While it is convenient to look at 43D5 and a prima facie test as something that might allow for judicial discretion, scratching underneath the surface, it's apparent that there is nothing of that sort that is available to the courts. What it actually allows for is taking away the powers of independent review that courts ordinarily are granted in matters of bail. I know it was read earlier, but it requires a rereading in this situation. So let me just look at 43D5 and just the relevant part, which looks at, notwithstanding anything in the code, persons will not be released on bail unless the public prosecutor has been given an opportunity of being heard, provided that a person shall not be released on bail if on a perusal of the case diary or the report made under section 173 of the court is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true. And as Mr. Ovesi pointed out in 2008, a case diary is not going to contain flowers about the accused. The issue of the UAPA, frankly, is part of a larger story. And that's what I really want to come back to. If you look at the history of bail, and this is something that I had the chance to recently write about, there has been a recognition that courts can't be trusted with unfettered discretion in certain scenarios. But at the same time, those are not courts such as the Sessions Court or even the High Court for that matter. Those are magistrates' courts. And that is something that you still find in section 437, where there is a restriction on the discretion of magistrates' courts to grant bail in cases that are punishable with life imprisonment or even with death. What UAPA and allied offenses, such as the now repealed TADA POTA, or what are still there in the form of the NDPS Act or even the Companies Act today, what these statutes have done is that they have cast fetters upon the discretion granted to higher courts as well. And that is something that requires serious consideration. Because what the message that is being sent out is that we do not trust the courts with unfettered discretion. The executive wants to rig the game for it to be played by its own rules. So what you have in other clauses is a requirement for the accused to establish that she is not guilty of the crime. And what is the basis for triggering that requirement? A mere opposition by the public prosecutor. Similarly, in the UAPA, mere opposition by the public prosecutor requires a court to look at the case diary and trust the version of the case diary wherever it is found. Now, these are serious inroads. And if you look at history, as far as these provisions are concerned, surely we had these provisions even at the time the Constitution came into being. This was there in the form of the Essential Commodities Act. In fact, at that point in time, it was called the Essential Supplies Act, where for the first time, this kind of a clause was built in. But when the provision came up for interpretation before the Calcutta High Court, it did not agree with an interpretation that would fundamentally alter the burden and take away the presumption of innocence at that point in time. So there was some pushback from courts. Fast forward post 1975, and curiously post the decision in Maneka Gandhi by the Supreme Court, you had a spate of legislation that provided for this kind of a restrictive bail condition. And each time, the conversation from the end of the parliament was the same. This is an exceptional situation that requires an erosion of safeguards. From one exception, it seems that today we have just kept moving from one exception to another. What began as erosion of safeguards within TADA's context then spread to NDPS, and now is even there for ordinary offenses under the Companies Act. Surely the buck has to stop somewhere. In respect of conversations, sorry, just the last point. In respect of conversations, and this is something that I've been at pains to point out elsewhere as well. Ultimately, as Rebecca ma'am also argued, and as I've tried to show, the process under the UAPA is not something that stands separate from what are the broader contexts that are surrounding it. Because there are concentric circles, and the UAPA is the smaller circle within a much broader context. And why is it necessary for us to not look at the UAPA in isolation? Is because ultimately, nowhere in the scheme of things do laws operate in isolation as far as the Indian criminal process is concerned. Now, what do I mean by this? It works at the lowest level up, right? So what you have is the same judges will on deputation handle various kinds of cases. It is not that there is only a fixed cadre of judges who are handling UAPA offenses. It is not that only one agency is tasked with prosecuting UAPA offenses. These are practices embedded within the system that are not restricted to simply one silo. They seep across contexts, which is why it is really necessary for us to also look past just that one silo and look at the broader context when we are initiating conversations about reform, where hopefully now this is the tipping point. Surely there can't be anything beyond what has just passed. And yeah, that really is the long and short of it. So Megha, if you had any comments, I'd be happy to answer that.
Thank you. So I had the same thoughts which before this session started, and I think you've written somewhere that there are actually one of the major problems of our criminal justice system is that there are no guiding principles as such for granting bail. It depends a lot on the individual discretion of the judge concerned, and this problem especially gets heightened with laws such as the UAPA, because then there is this overwhelming specter of national security which kind of hangs over every judge when they are looking at these kind of cases where, you know, there's a allegation of someone being a terrorist or of conspiring against the state. And even in discussions with lay persons who are basically your voters, who are in charge of kind of putting pressure on the parliament to change these laws, they would not be really opposed to these kind of provisions, because then the moment you say it's about terrorism, it seems to kind of strike some sensitive chord within people, regardless of whether the person accused is actually involved in terrorist activities or not. So, to what extent would you say that, you know, the very fact that you have these kind of special laws which carve out exceptions for, say, special things like terrorism or unlawful activities itself is a problem? Do you think it would be better if we were just to move to a kind of system where all cases are treated by the same set of principles when it comes to granting bail or even criminal procedure generally?
So thank you for that.
When would that be? When would your session think?
Sorry, was that at my end? Sorry. So I was saying that I had two leveled responses to that. The first is the ideal, and the second would be the practical. As far as the ideal is concerned, absolutely. And I agree with you that there would be ideally only a general regime that operates. There is, frankly, the moment we step into this role of creating exceptions, it is a slippery slope of no return. One exception in one context is going to be met by another exception, another emergency when
Mid-August, 15th of August till then.
I think someone's mic is.
Could everyone please switch off their mic?
Then,
I think it's at ma'am's end. If I think it might be possible for the organizers to. Is it?
Yeah, you can.
Is it better?
Yeah, it's.
Yeah.
Please continue.
Sorry. So I was saying that as far as the ideal is concerned, that really is the situation that you would want. And just on that, I remember there is a piece by a scholar called Nasir Hussain. This is not the book, but an article by him that talks about special regimes. And this was written by him, I think, in the context of special courts that were coming up in the UK and in the US following, 9/11. Various courts, even in the UK, the anti-terror regime has really taken up the idea of exception. So he argued against this, where he showed that one exception in one situation, that's not where the line is ever going to draw. It is always going to be a line in the sand. But having said that, you do recognize that that ideal is something that may never be seen in practice. And so where you come at practice, what you require and what you hope for is a degree of care that you entrust legislators with. The hope is that that degree of care will be not something that is ordinarily given a go by. That these laws are not drafted in a hurry, that they're sent to select committees, that they're not looked at only in context of, let's say, the bail clause. Because as I tried to highlight, that bail provision is not operating on its own. What makes that bail provision sinister is just how easily UAPA itself can be added as part of an allegation. And that's because the offense under the UAPA is so broadly categorized. So unless we look at the statute as a whole very carefully, when we are creating an exceptional regime, that burden ought to be very high on the legislature. Having said that, the one guiding principle that you would hope for is that the power of the judiciary can't be taken away in the manner that has become the norm for our special laws. It has to be flipped from where we are today, where rather than take away the powers of the court in respect of matters of bail, courts have to be given a free hand, as they are given in every other situation, as they are given in offenses of murder. So a sessions court today under section 439 does not have restrictions of the kind that it has, let's say, under the Companies Act or the Prevention of Money Laundering Act, for that matter. The step forward would be to regularize bail, at least for the higher courts, in the form of the sessions court or the high court, so that there can be some pushback to allegations, unfounded allegations leveled by police agencies because of the manner in which offenses themselves are drafted.
Thanks, Megha, for inviting me here. Rebecca and Abhinav have already covered most of the ground, and therefore I'll just weed along trying to find out the spaces which give me a little bit of scope to speak about. Let me just start by saying that, and I will also talk a little bit more about Stan Swamy's case because I was involved in that case. But before I do that, let us understand one thing, that the capacity of prisons in India today, okay, is approximately 3 lakh. That is, 3 lakh prisoners can be accommodated in a prison. Yeah. In the prisons of India today. You have more than 4 lakh prisoners today in the prisons in India, so they are already overcrowded. On top of it, more than 70% of these are under trials. Okay, so it also reflects on the general, bail situation, and not just the UAPA, but also the general bail situation, where 70% of of the people in prisons are under trials. It shows how difficult it may be for many people to get bail, even under ordinary law. It may be, and obviously most of these people are poor people who cannot afford either, who cannot get a surety, who are unable to show that they are rooted in the society, etc., various other reasons. So generally also it's a problem. And it was in that context, and I go back to what Rebecca said about the high-powered committees which are set up by the Supreme Court in the COVID scenario, where the Supreme Court said that each state will set up a high-powered committee to decongest the jails, because they also realized that jails are congested, and this congestion was, the overcrowding is there even in ordinary times. So for COVID times, it was 10 times more, the overcrowding. So they had to be decongested. And the high-powered committees consistently came to the conclusion that everybody else can be released, but not those charged under the special acts. A petition was filed in the Bombay High Court challenging this provision, saying that how can you not, how can you refuse a person from being released on a temporary time frame because of the COVID situation, only on the ground of what is the allegation, I mean, which is not even proved as yet. Okay. High Court said no, nothing, no, there is nothing wrong with it. The matter was carried to Supreme Court, and Supreme Court, I may say, characteristically said that there was nothing wrong with this kind of provision, and let the people who are charged under UAPA or PMLA or MACOCA or any of these other special laws not to be released. And so and therefore, Stan Swamy continued to be in jail. Let's be clear about it. Okay. So while I do blame, and I do feel that ultimately the blame for Stan Swamy's death lies with the fact that he was arrested. Okay. I mean, if he had not been arrested, he would not have died. I mean, obviously all of us die at some stage, but not in the manner in which he died. But at the same time, we have to also understand that there are a series of other things which have happened, which have led to his death. Okay. And I was mentioning the Supreme Court in that context. Okay. So if one has to lay the blame, one has to lay the blame at various levels, not just at one level. Coming back to UAP, and then I'll come back to Stan Swamy. You see, UAPA creates an offense by association. Okay. So what happens is that mere membership of an organization, okay, a banned organization, okay, or an allegation of mere membership of a banned organization is enough to put you behind bars. Yeah. Now, two things happen here, and that is, I think, important to understand. One is that initially, in the late 80s, etc., late part of the first decade of this century, I'm sorry, a number of cases were filed where the people were said that they were arrested because they were members of an organization, of a banned organization. Supreme Court then came out with a series of judgments, 3-4 judgments, where they said that mere membership cannot be a ground to implicate you under this particular law. You have to be an active member, okay, in order to be implicated. Of course, that judgment itself is coming up for reconsideration. We don't know what will happen at the end of the day, but that is also coming up for reconsideration. That's a separate issue. So once it was held by the Supreme Court that mere membership is not enough and active membership is necessary, the investigating officers started creating ways in which you are able to show that somebody is not merely a member, somebody is an active member. Okay. And one of the ways in which they've shown, and they did it in this particular case, or in Bhima Koregaon case, and they will, I'm sure they will do it in various other cases, is by using what is known as electronic evidence. Okay, that my computer is seized, and on my computer there is something which is found, which may have been planted on my computer, and which, according to us, has been planted on these people's computers. And on the basis of those planted evidence, you are trying to show that these people are guilty of certain terrorist acts. Yeah. And once this kind of a defense is, and once this kind of a narrative is put forward by the prosecution, then the courts normally refuse to grant bail. This is what has happened, despite the fact. Take the example of one of the persons who has been arrested under the Bhima Koregaon case. Say, for instance, Mr. Rona Wilson, who's a Delhi University professor, who was arrested, and they said that from his computer, a letter has been found written by X to Y, referring to Mr. Anand Teltumde, who is the head of the Goa Institute of Management. It is nobody's case that Anand Teltumde wrote that letter. It is nobody's case that Anand Teltumde received that letter. It is not nobody's case that Anand Teltumde he was the addressee of that letter. But on this basis, they say you are an active member, okay, and you are arrested, and he's in jail for more than 2 years because of this kind of an allegation. We were able to show by getting evidence from experts, forensic experts from abroad, that this evidence is planted. Okay? But we don't know whether that will be enough to get them bail. I mean, that the whole problem with the bail jurisprudence, which Abhinav as well as Rebecca spelled out for us. Okay, this is the problem, that even we obviously planted evidence you are unable to show that this is you can't counter it. I mean, at the stage of bail, you will counter it at the stage of trial, which may happen 10 years, 11 years down the line. Okay, but you won't be able to counter it at the stage of bail. People's lives are destroyed, families are destroyed, everything is destroyed. And please be very clear that these are not mistakes made, honest mistakes made by prosecution. It's a deliberate attempt to muzzle all kind of dissent. That's the game plan. The game plan is not that, okay, in trying to arrest 10 people, you get an 11th person by mistake who is arrested by mistake, and then the mistake is realized by the court and then he's released. It's not that kind of a situation we are living in. We are living in a situation wherein there is a clear attempt for any dissenters from the civil society to be branded, to be implicated on the basis of false evidence, to put behind bars, which has a chilling effect across the society. You see, this is the situation. And this is what happened with Stan Swamy. Now, remember one thing, as you mentioned at the beginning, okay, the FIR was lodged in respect of the Bhima Koregaon case on 8th of January 2018. Stan Swamy's house is raided in August 2018. We filed a petition in the High Court saying that what is happening. The prosecution said, no, we don't want to arrest him. He's not an accused. Okay, so the matter gets over. In 2019, again his house is arrested. The house is raided. They seize his computers, etc., etc. Again, they don't do anything. They don't find anything. 2020, again, the house is, and remember one thing, he lives in a small ramshackle place called Bagaicha. It's one room, doesn't have AC, has a fan which works once in a while. Okay, I have stayed with him. I know Stan Swamy since last 30 years. He's my client, yes, but he's not just my client. Okay, I've known him for 30 years. I've done some legal aid trainings with him, etc., for the tribals at Chaibasa, at Ranchi, etc. So I know the man. I'm a very humble, very modest man. The outpouring of grief which has happened after his death, okay, is not just because he died, but because he was also a very popular person. Okay, he was popular not because he was a gun wielding person. He was popular because he devoted his entire life for a peaceful resolution of the tribal issues. Anyway, so he was finally in October 2020 he's arrested. He's arrested, taken to the jail. He's not arrested for the purposes of interrogation. Remember one thing, normally people are arrested in order to interrogate them. One of the reasons being to interrogate them. So you ask for police custody, 15 days, 30 days, and at the end of the police custody, then you are sent to jail. Okay, because they want to interrogate you within the police custody. Stan Swamy, they did not ask for a single day's police custody. Okay, the investigating agency did not ask for a single day's police custody. Immediately from the court, he was sent to the jail, not for a police interrogation. Interrogation was over much before he was arrested, even according to the prosecution. Remember that. That is the situation. He's arrested. He's put behind bars. Everybody knows, you must have heard about the problems which he faced in the prison, because the prison conditions, even ordinarily, okay, are very, very bad. Health-wise, they are very bad. In terms of congestion, they are bad. Plus, in COVID times, they are even worse. That's the situation. So now, in that kind of a context, he and you have all heard about the SIPR and all those problems. I need not really repeat those things. Okay? So the conditions were very bad. But when he stepped into the into the court, into the jail, at that time he could, okay, move about on his own. He could walk around on his own. He could go to the toilet. He could take a bath on his own. He could eat on his own. He needed some equipment, etc., but he could do all that. Finally, his bail application was, we had filed 2 bail applications in the special courts. One bail application was for medical bail, and the second bail application was for the normal bail. Okay, medical bail was rejected. Normal bail was rejected. Okay, And then the appeals were filed in the High Court. And at all stages, the National Investigating Agency, which was a prosecuting agency, opposed all kinds of bail. They opposed his hospitalization. They opposed medical. They even opposed the SIPR part of it. Everything was opposed, at all stages. Okay, so that is one thing which you have to keep in mind. And then finally we went to the High Court. In the High Court judges were, you see, by the time the matter reached the High Court, his health was quite bad. And the judges were good enough to talk to him on the directly from the jail, directly asked him to do a virtual hearing with the court in jail. And at that time he said that, look, this is ridiculous. Don't send me to this government hospital, which I have been there twice, and there are no facilities, nothing. Don't send me there. What's the point? Okay. So then the court agreed that, okay, he should be sent to a private hospital. Okay, which is not normally done, but it was done in this case, and that he was sent to a private hospital of his choice. But by the time he reached the private hospital, his health has deteriorated considerably, because as he mentioned to the judges when he was talking, that, look, when I came in, I could walk, I could eat, I could go to the toilet, I could go do everything on my own. In the last 6 months in the jail, I have collapsed. I can't walk. I have to be brought here. I need a wheelchair. I can't go to the bathroom on my own. I can't eat one thing. I eat a chapati on my own. That's my situation. Okay. And why was this situation allowed to happen? Jails, and this is a central jail, which is a hospital of its own inside the jail. Remember, central jails are hospitals. Of course, that hospital is that hospital has totally three Ayurvedic doctors who give allopathic treatment all the time, so that's the situation scenario of the hospital. But they have a hospital which cannot do even a blood test because they don't have facilities. But there is a hospital. Okay, so finally he was taken to the private hospital. By the time he was taken to private hospital, on the first day, the private hospital realized that this man has COVID, because he was showing all the symptoms his last 7 days. Now, 7 days before he was shifted to private hospital, he was showing all the symptoms. He was not tested once. This is the scenario. He was not tested even once. Okay. Though he was showing all the signs. Then they realized he had COVID. He was put on treatment. Unfortunately, because of his age, because of his conditions, etc., he did not survive. Okay. Fortunately, in fact, what happened was that we mentioned the matter on a day when the matter was not to come up. The court was good enough to grant us, allow us to take up the matter on board. Unfortunately, by the time the matter came up on board, he had already passed away. An hour before the matter came up on board, he had passed away. The matter is kept pending. It will come up on Tuesday, because we said that we want a proper investigation into the death of this person. But remember one thing, that a whole lot of circumstances are responsible. But the primarily what I feel is two things which are very responsible. One is the fact that he was arrested on flimsy, fabricated charges. Fact that you arrest a person, you don't arrest a person in 18 when you raid his house, not in 19 when you raid his house, but in 2020 when COVID is raging, you arrest an 84-year-old man who is anyway suffering from Parkinson's disease, etc., etc. That shows your intention. That's the first thing. So arrest itself, okay, is, according to me, deliberately done in order to ensure that the man doesn't come out. Because if you are going to oppose his bail and say that till the trial happens, we are going to oppose his bail, the man will not come out. Okay, so it's a death sentence. The arrest itself was a death sentence. That's the first thing. The second thing is that the Sessions Court not granting the bail, not granting even interim bail on medical grounds. Because remember one thing, that medical grounds bail, okay, is a ground of bail which is available, okay, even in respect of people who are under UAPA, because you do not lose your right to life and personal liberty. Okay, even if you are charged, even if you are under UAPA, Varavara Rao, a co-accused, was given medical bail a few months back on the footing that yes, you are charged under UAPA, but your medical condition is such that you need to be given bail. Okay, and that right to get medical bail isn't taken away because you are charged under UAPA. But by the time the whole thing, and despite that, the Sessions Court refused the medical bail. Okay. And so I personally feel the entire, you see, the whole thing is that this UAPA, the act itself is, and I totally agree with both what Rebecca said as well as Abhinav said about the bail jurisprudence, about how it, how a state of exception is being extended more and more and more to include newer and newer categories of offenses, because our government, and I'm talking about any government, if there is something serious which ever happens, whether it's a rape case, whether it's a terrorist offense, etc., the only response is to bring in death penalty, bring in this, bring in, and that's the only response. You see, I mean, you make the law stringent and tell the people at large that, look, we are acting. Okay, not that it makes a damn of a difference at the ground level, but this is how it works, and this is what has been happening with the terrorist UAPA Act. And as Abhinav himself said, that you see, all these offenses are offenses which can be definitely be tried under normal law, because our normal IPC provides for waging of war. There is a provision, there is an offense called waging of war. There is you can do that. Sedition is there. There are various offenses. So I would like to end that by saying that it's extremely sad, and it was very heartbreaking to see Sten die. At the same time, I hope that the silver lining to his death would be that it starts a larger debate and a larger movement for repeal of this kind of laws, in order to ensure that such things are not repeated in future. Thank you very much.
Thank you, Mr. Desai. So I just had a follow-up question on that actually. Thank you for making that point about, you're absolutely correct that, we have regular provisions for these things, but still the government chooses to go ahead and enact these special laws just so that it can appear tough on crime and things like that. There seems to be a kind of section of discourse on social media which links the misuse of the UAPA with a particular government. And, the argument seems to be that you generally do need these kind of laws to target terrorism. It's just that they are being misused by the current establishment. Given the years of experience that you have had, across successive governments, how much do you agree with that? Do you think that it's just a problem of misuse in this one case, or do you think it has always been an instrument of oppression right since its enactment by the executive?
Well, the answer is yes and no. Answer is yes and no, in the sense, remember one thing, TADA was brought in by the Congress government. Okay. UAPA amendments were, UAPA originally was brought in by the Congress government way back in '67, and the amendments which are the ones which we are talking about, the bail provision, all were brought in by the Congress government. Okay. TADA was heavily misused. POTA was heavily misused. Both TADA and POTA, however, had sunset clauses. They were seen as laws which are basically for a limited period to meet a limited situation. So every 2 years or 3 years, they were required to be brought back before Parliament in order to renew them. Okay? That does not exist under UAPA. UAPA is a permanent law. Okay, remember that. That's one thing. The second thing is, yes, these laws have been misused even early, and I wouldn't even call them misuse, because I think this is the use for which they were made. So it's not a question of misuse, it's a question of putting them to use. Okay. But I do feel that yes, they were misused earlier also, and they are being misused today also. But I do feel that present government, present establishment, okay, is using it much more to silence the civil society, okay, in a much more targeted manner. Okay. Look at the people, for instance, just to give you an example, in Bhima Koregaon, who are the people who are involved? Academicians, okay, cultural activists, Dalit right activists, lawyers, journalists, okay, and the whole range of people, civil rights activists, human rights activists, the whole range of people. Okay. Similarly, students in, if you look at what is happening in Delhi. Okay. Now, this kind of targeting, this kind of selected targeting was not happening earlier. Was it being misused? Yes, it was, definitely. Okay. But this kind of selected targeting to crush all kinds of dissent is something which you are seeing much more now. That's how I look at it.
Thank you. So I also have some general questions which the viewers have asked. I'll just kind of paraphrase them, and whichever of you wants to answer it can answer it. So one question, and this is a concern that I have as well, is that somebody has asked that when discussions are held on these subjects amongst people who come from a legal background or say a certain academic background, there is a kind of lack of presumption of the fairness or constitutionality of the law passed. Or if I would rephrase it, I would say that amongst legal professionals, we are trained to believe that there is a presumption of innocence and certain due process safeguards should be there. However, a great portion of our society presumes that these laws are in fact fair, and any discussion about the use of these laws by the present regime is heavily tilted in the state's favor. How do we as law students facilitate an open discussion with the people around us?
Abhinav, why don't you go ahead? You are closest to the law students in terms of age.
Sure, sir. I take that as my cue. What I would suggest is that, I mean, I also agree with that assessment in the sense that there sometimes can seem to be a bridge that has to be crossed, but the only way to facilitate conversations is to acknowledge and not to rubbish those considerations, but to acknowledge the fact that those considerations do exist and they will continue to exist. Because in that moment, when, for instance, there was, let's say, an attempted attack on the Parliament building in 2002, it's not that nobody is denying the fact that there is a real threat of violence, right? So it is necessary to acknowledge that fact. But at the same time, the role that our training as law students sort of helps us is and we hope that it gives us the necessary level of critical thinking to be able to look past the emotion that gets generated in the moment and be able to question that. Because ultimately what is being passed in terms of the legislature is something that might be driven by that moment, but it is something that is going to be passed for time immemorial, especially where no sunset clause is being incorporated within the statute itself. So I think acknowledging it definitely is the first step, but then hoping that our training as law students to be able to critically examine the consequences of decisions allows us to facilitate those discussions when they are happening in society.
Can I just add on to that a little bit? It's a slightly different conversation I'm starting. See, and Abhinav will probably be able to understand what I'm trying to say because he's also part of those cases, the Delhi riot cases. Lot of the accused persons who have been charged under the UAPA also have other cases against them, which are happening simultaneously. Some of them under 302, others under 307. So a gamut of serious cases. The client I represent has a total of 3 cases against him. One is a 302 case. Now it's worthwhile looking at the evidence in the other cases. Almost all these accused persons are on bail in those other cases. So my client, Khalid Sekhri, is on bail in a case in which he's charged with murder. The court went as far as saying, what is this case? It looks like a total setup because there is not an iota of sustainable allegation against him. However, when it comes to UAPA, because of all the drama that surrounds UAPA, he remains in custody. So it begs the question, when you're prosecuting someone for a specific offense, for a specific act of, say, murder or causing grievous injury to someone, he is released on bail because the evidence is unsustainable. But when it comes to UAPA and all the attending presumptions against him, he is still languishing in jail. So I think as law students, we need to, and we're also students, we keep learning every day. We need to look at this outside the framework of of prejudice. We need to look at this in a different way. Let us look at the material. I'm saying challenge us and tell us and ask us what is the material, and see whether those allegations are sustainable. Because in the Delhi riots case, unlike the Bhima Koregaon case, we have multiple cases against the same accused persons. So a person is guilty of causing a riot at place X and causing injury to person Y. He's guilty of committing murder in place Z of person A. And he's also guilty of conspiracy and the larger charge of UAPA in a third FIR. But all the individual cases are collapsing. So this is a very good way to test whether the charge of UAPA in a separate FIR is sustainable or not. And one does have to ask the question, if you're prosecuting them for these individual offenses, what is so special in this last offense in FIR 59? What is it that you're prosecuting them for, other than some fairy tale that you've developed in your police station?
I just wanted to add a little bit. I think when we look at, for instance, UAP and acts like that, in today's time, you should also look at sedition, for instance, that the way, I mean, and what happens is that, especially with young middle-class people, more so, that I mean, generally sedition is misused rampantly, but it becomes a major issue when a young student is charged with sedition for having made a toolkit. Okay, then it becomes a really something which everybody suddenly feels affected by, and so I think it's also important for students, not just for students, for everybody, okay, to be grounded in what is happening in reality, okay. Not just to middle class people who are obviously charged with false cases, but much more than that. Okay, where, I mean, look at what Father Sten was doing. There are 3,000 tribals in jail in Jharkhand, okay, for having opposed displacement, and he was fighting that case by filing a PIL in the High Court, for which this ultimately all this came to. But we don't talk about those 3,000 people who are in jail in Jharkhand, you know. So it's equally important, okay, to also become aware of the reality which is around us, and not just with the popular, with those cases which trigger the popular imagination, you know. That is the other thing. Thanks.
Thank you. So there's another very common question that everyone seems to be asking, is that funnily enough, as lawyers, we do tend to recognize the kind of issues that are involved in these cases, but when it comes to the level of the judiciary, there seems to be a perceived hesitance to declare the law or even the specific provisions on bail as unconstitutional or arbitrary. Why is that so, and how do we bridge the gap that occurs between the executive representing the cases in a particular narrative and the court taking it as a kind of edifice to decide that, you know, prima facie a case is there, so therefore bail should be denied?
Rebecca, why don't you, or Abhinav?
I wish I had a good answer to this question. Why is it that the judiciary is looking at it so differently then? And I don't have an answer. I can only say that, you know, when you put this kind of hydraulic pressure and you kind of make it a sustained campaign, these are horrible people who did these horrible acts. It ends up in a situation like that, coupled with the fact that you have laws which limit judicial discretion. Ultimately, if courts want to release people on bail or want to give pro-citizen judgments like the Delhi High Court has done recently, nothing stops them from doing so. But you know, I don't know. I think the time has come for the judiciary to ask these very, very serious questions. Mihir talked about the toolkit case. We were all involved in it at some level or the other. What was it? I still haven't understood the case, even though I argued it. It was just a bunch of random facts put together, meant to defame India, etc., etc. But a trial court did grant bail to Disha Ravi and did grant protection to the other accused persons. So I think while we are looking at this regime very critically, and we are conscious of the fact that courts are being are not really performing their constitutional duties, at the same time there are courts who are doing it, and I think. As more and more courts begin to do it, we will probably have a fairer regime. I think most of us are happier in the spaces that we normally operate, which is trial courts and high courts. We are a little unsure when it comes to the Supreme Court.
Very politely.
I had my hand up. Yes. I was going to say something that is slightly controversial, and this is something one of my mentors used to say when that we have a very status quoist system where it's very easy for decisions not to be made but deferred, especially when it comes to issues at the front end of the system, when it comes to issues of custody, or it comes to bail, or it comes to extending judicial remand. The pressure that is involved in making a decision either way, even dismissing a bail application, the easiest out for most judicial officers ends up being to delay and defer that decision so that someone else has to make it. And frankly, I don't know what is the answer to that, but in my experience, at least, until that itself is questioned, where that decision making itself is not something that is seen as such a hard ask, that I don't know. And like Rebecca ma'am also said, I don't have a good enough answer. But ultimately, that perception for me is something that will take some time to, and I'm sure sir and ma'am can contribute a lot more to that given their wealth of experience. But in the short span of time that I've had, that's something that really comes to the fore: the ability to not make a decision, just let someone else make it, or we'll keep it pending for another day. Let's look at it later. So yeah.
Yeah, I just wanted to add one thing. Even if you look at the bail jurisprudence, even if you look at the special courts jurisprudence in the last, it's not as if it's only in last 2-3 years that things have moved from bad to worse. I mean, UAPA's constitutional challenge was rejected in '93. AFSPA was rejected sometime later. POTA was rejected in the PUCL petition, etc., etc. So this has been happening. But what has been at the same time simultaneously sometimes happening is that when they realize that there is gross misuse happening, okay, Supreme Court has from time to time stepped in, okay. Whether it was in the Shaheen Welfare Society case when they were dealing with UAPA bail, and they said that okay, bail can't be granted easily, but then let's make 4 categories of people who may or may not be granted bail. Similarly, now in Najib's case, for instance, the Supreme Court saying that yes, bail provisions, yes, we can't grant you bail, but since you have already spent 5 years, you also have a right to speedy trial, and since you speedy trial, your trial won't be over for a long time. Therefore, recognizing your right to speedy trial, we are giving you bail. That particular part of the judgment was brilliantly and creatively interpreted by the Delhi High Court in the recent cases, when they said the right to speedy trial doesn't get defeated only at the end of 5 years. Okay, if I know even on the first day that this trial is going to take a long time, Okay, I need not wait as a judge for 5 years in order to release you on bail. I know this, looking at the backlog, looking at the amount of witnesses you have, etc., that a trial is going to take 5 years. So I can say today that your right to speedy trial is affected. I can release you today. That's a very creative interpretation given by the Delhi High Court. But let's see what the Supreme Court does about that. We don't know right now what will happen. So it goes back and forth, but what Rebecca was saying was absolutely right, that the Supreme Court, and what happens is once the Supreme Court lays down a conservative decision, it follows down the line. I mean, the High Court and the Sessions Court, if they don't want to give a bail, they can easily rely on that decision and say that, well, what can we do? Our hands are tied, kind of thing. So this, yeah, that's the thing.
Thank you. Just one last question before we end the session. So on that Delhi High Court judgment, actually some people have concerns with the High Court judgment insofar as they feel that the High Court may have gone too far in terms of laying down a certain precedent in the context of deciding just a bail application, and they are worried that it might be set down, it might be set aside at the Supreme Court level. What are your thoughts on that?
I'm refraining from any comments given my fault.
No, I think, Abhinav, you should speak, because I don't think the High Court I think it was a very measured judgment. If you look at the judgment structurally, it's taken into account the arguments of both sides. It has taken into account the various precedents. And it's come to certain practical considerations in its interpretation of Section 15. It's looked at the evidence and say it doesn't cross the prima facie threshold. So, you see, this is the problem. What I said in my address. You say an accused must be able to show that the prima facie threshold has not been crossed. How can he show it unless some of the evidence is discussed? If that evidence is not discussed and you still grant bail, the Supreme Court will say, what a non-speaking order this is, reflects total non-application of mine. So whichever way you look at it, you're basically perpetrating a regime where bail cannot be granted. How could the High Court have come to a conclusion that these offenses are not made out and that the barriers under 43D5 will not apply unless it cursorily glanced through the evidence that was against these three persons? So you have to look at the evidence. I think the statute demands it. The Supreme Court, as I said, in Vatali's case, did exactly what it was blaming the High Court of doing. It examined the evidence and it came to the conclusion that the case is made out. So I don't think the judgment is in any way excessive. I don't think, just because you don't have to count the number of pages, I think it's a measured judgment. I think it was required to be written in the way it was written, irrespective of whatever happens in the Supreme Court. And I really hope that the same is upheld.
Yes.
I think everyone.
Yeah. Sorry, Abhinav, you wanted to say something? Go ahead.
Nothing. So I was just saying that that absolute, and just to sort of share for everyone what had happened on the day of the Supreme Court hearing, and that sort of ties into what ma'am was saying. What really stood out for the court as something that was exceptional and something that the court suggested merited a stay order was the fact that the bail judgment went into 100 pages. And as any reasonable person is bound to ask oneself, if you are asking the court to enter into a prima facie appreciation of materials for the question of bail, in a case where the charge sheet runs into 10,000 odd pages, charge sheet where I'm saying the documents itself along with the opinion of the prosecution itself, all of that runs into frankly around 17,000 pages. Is the outcome going to be anything less than a reasoned judgment that looks at all factors in double spaced line spacing and that runs into about 100 pages? And this is something that the Supreme Court found so shocking that itself was good enough for the court to consider granting a stay order. And as ma'am said, it's a situation of you being damned if you do or damned if you don't, because where you don't enter into an appreciation of the material, that order is liable to be challenged. And if you do, then you are tiptoeing around the big no-go zone that is sort of created by the judgment in Vatali, where you can look at it, but you cannot look at it in a certain level of, scrutiny. So it's something that, I mean, there is no question of saying that judgment was not required, and it's frankly totally within the bounds of law. And let's see what happens as far as the Supreme Court is concerned.
Well, either the Supreme Court will make a departure from Vatali, or this will be Vatali 2. So we don't know what will happen at the Supreme Court level. But I also agree with what both of you are saying, in the sense that there was no other way to do it, in the sense that what does a judge do? What do the judges do? They basically say that the offense of terrorism is a terrorist activity is not attracted in this particular case on the basis of what is produced. In order to do that, they had to go into what do you mean by terrorist activity. That's what they go into. Okay, so they have followed a very logical path. They say that 43D does not apply. I'm not bound by those conditions because UAPA does not apply. That's what he says. He doesn't say that UAPA applies, and still, of course, he says that in a way, because he says that even if UAPA is applicable, then also A, B, C, D, he says that. But these are the two parts of the judgment. One, that UAPA doesn't apply. Two, even if it does, still these people need to be released on bail. Both the things it says. I think it's an excellent judgment. I know a lot of people have said that it's gone too far or whatever it is, but I don't think they had a choice but to, if they wanted to give this judgment, they didn't have much of a choice but for going into definition of terrorist activity, etc., which they've gone into, rightly so. Let's see what happens in the Supreme Court. Vatali's even the typed copy of Vatali's judgment goes into 100 pages. We should remind the Supreme Court of that.
Thank you. I think Sarthak would like to give a vote of thanks on behalf of LawSoc.
I'll try and keep this very brief. We have been here for close to 2 hours now, and I'm extremely thankful for all the panelists for taking their time out this evening and joining us for what has been a truly fruitful discussion. We had over 100 people in attendance who benefited from your experiences, your insights into the law, the jurisprudence around bail. And we'll try and put out a report on the talk as well, so that people who did not attend it today can also benefit from these insights in later discussion and discourse around the subject. Presently, I'd like to I'd like to present my humble gratitude to all of you for joining us today and for starting this conversation anew in light of Father Stan's death. And we hope that the kind of discussion we have today, the kind of discourse we begin today, goes ahead and creates a material difference in the world, the material difference in the law.
Thank you very much for calling us. Thank you.
Thanks a lot.
Thank you.
Thank you.
Thank you so much for joining us.